Hi, this is Ed in San Diego, and you're on Global TV Talk Show. In just a few minutes, we're going to be joined by a distinguished barrister, Angelo Paparelli, a partner at Vialto Law. He serves global businesses and their employees by providing creative solutions to complex and straightforward immigration law problems, especially involving mergers and acquisitions. PERM, that's PERM, labor certifications, and employment-based work visas and permanent residency. Angelo Paparelli has over 40 years of experience in the field. He has developed a reputation as an immigration law star, a certified specialist, and an award-winning blogger. And I'm really honored and happy to welcome Angelo Paparelli to Global TV Talk Show. We'll be back in just a minute. Take care. Hi, this is Ed in San Diego, and welcome back to Global TV Talk Show. Our very special guest today is in LA, and Angelo Paparelli, who is a partner with Vialto. Welcome, Angelo.
It's nice to be with you, Ed. It's good to see longtime friends.
Indeed. Thank you very much. I'm really honored to have you. So you're a specialist for many years in immigration, businesses and individuals. And I have a couple of questions here, and you sent me some talking points as well. So we're going to have a track to run on, but basically it's conversational. The audience out there is US and global. In the weeks and months subsequent to today's recording session, this program will be distributed through LinkedIn and Twitter and YouTube, Facebook, and our own links. More than 100,000 audience views will see this over the course of months. So with
Let's
that
hope
in mind,
I don't slip up in any way. But you add to the pressure.
no,
But
no
no stage
pressure.
fright. No
No,
stage fright. Don't worry about it.
no pressure. So why did you leave Big Law and join Vialto?
Well, I had been very comfortable in my role as a partner in my last firm, where I was there for 14 years. I've had a total of three large multidisciplinary law firms where I practiced and did so well. I also had my own firm, which grew to 15 lawyers over a 10-year period. And so I'd pretty much done everything you could do within those environments. But when I heard about the opportunity at Vialto, first of all, obviously everyone heard about the spinoff of PwC's tax, immigration, mobility, shared services, payroll platform to a private equity firm for an eye-popping sum. And that created a lot of buzz around the subject of who is Vialto and what does Vialto Partners plan to do. And so I was curious. And what I realized was that they wanted me to help them establish, really from ground zero, a new US law firm, because clients were clamoring for boots on the ground, nationwide availability of lawyers who express a focus on US immigration matters. I should say that PwC and then Vialto in Canada were very successful in their own right, and they still are. There are 45 immigration lawyers practicing US law out of Canada. But the clients wanted more depth, a deeper bench of experts to do that. And so one of the things I'm doing is attracting lawyers who are interested in a tech-enabled delivery of legal services. So much of today's, especially the larger corporate client demand, comes from the need to integrate into a seamless dashboard multiple disciplines. You know that global mobility, relocation, immigration, tax are part of an ecosystem, and oftentimes the same people wear multiple hats within the organization. They may be responsible for immigration, they may be responsible for tax, or even if they're only required to focus in one of those areas, they need to know what's going on with their people in the allied practice area. So Vialto has allocated a budget in the multi-millions to provide that kind of an integrated dashboard. It's dedicated resources that are far beyond what a traditional U.S. law firm, especially one that is multidisciplinary, can offer. As you might expect, a law firm that has many different practice areas will face demands from all of those groups and departments for resources. And those the resources are limited. And under the typical tax structure of law firms, they have to flush out all their cash at the end of the year. And so the choice is, do we take a profit percentage, or do we divert some of that money that would go into our pockets into heavy investments in technology that clients are demanding? And what I think is, this is a pure play. The other things that Vialto was asking me to do is to help open some doors in Washington within the government agencies and within the trade and business groups that are so much focused on immigration, like the U.S. Chamber of Commerce, for example. And I have done that already in my career, so I know the players. I've also maintained a blog since 2004, which respectfully, nationofimmigrators.com, which respectfully suggests to the government ways they can improve their performance. And I know from personal encounters with government officials who've taken me aside and said, thank you for that particular blog post, because it moved the needle on a conversation we needed to have in our organization. And I've seen that happen over and over again, where they are very sensitive to thoughtful demonstrations of ways that they can do better.
Okay, one more time. Give me the name of that blog
It's
site.
Nation of Immigrators, IMMIGRATORS.com. I found that the word immigrator has a distinct meaning, which is the first immigrant in a family that comes to a country. It's an obscure word, but I didn't want to say Nation of Immigrants because John F. Kennedy had taken that one.
So it's very interesting, just as an aside, regarding the December 7 meeting coming up in London at HSBC. My direct link in the bank is of Indian background, been in UK all his life, really. His parents did the immigration thing a long time ago. And he is in the bank at a senior position. He's in charge of the Indian diaspora, the India corridor, they call it, of
Right.
high net worth individuals needing a bank, an international bank, to facilitate their own activities and with safety and security. And so he's also involved with global mobility on a corporate level, a senior level, and the bank is developing, as I alluded to earlier, a new suite of products and services dedicated to the mobile talent at the executive level, in addition to servicing the high net worth sector. So let's
Well,
continue.
I mentioned
Yeah.
in terms of India, I've journeyed with the Indian business community for many years, starting back in 1994 when the ABA invited me to speak to the combined association of lawyers and chartered accountants. and I've consulted with some of the major Indian companies, and I've also witnessed the frustrations that Indian nationals who are highly educated, very talented, face under the immigration system, where we have decades-long quotas to get a green card. And so I've also visited India as a tourist, and just love the strength and the perseverance of the Indian people generally. So I can relate to what you just said.
Very interesting. Um, I have asked him, and his name is Cull, to look into attracting people from some Indian companies who were involved in the recent moonshot, the very successful moon landing.
Right, I saw that.
So that's still happening. I don't know who yet. Anyway, let's go on. Uh, what well, I think you already alluded to some of this, but I'm going to ask a question here. What is a major obstacle in recruiting and relocating top talent today from abroad?
Well, it's not news that today many professional couples
Hmm.
uh, have each have an occupation of their own. And when a recruiter seeks to attract one non-citizen to move from his or her country to another country, let's say the United States, the immediate answer is, what will my partner, what will my spouse do? And unfortunately, most of the time, some countries are becoming more attuned to this and are creating avenues for employment of the spouse. But the U.S. has been slow to do that. We did that, however, in two categories. One is the E category. There are three: E1 for for trading enterprises, E2 for investment companies, and the third is E3, which is a special visa for Australians. And then we did it also in the intra-company transferee L1 category, where Congress created a provision in the law that said the spouse could work. Now, the Immigration Agency, United States Citizenship and Immigration Services, or USCIS, which is a component of the Department of Homeland Security, long ago adopted a rather narrow interpretation. And they said, yes, the spouse can work if we give the spouse a work permit, but we'll take 6 months to issue it. And that was sort of a non-starter. At the dawn of the Biden administration, I was asked by the Cato Institute, which is a libertarian think tank that is very pro-immigration, to come up with some proposals for the Biden administration to improve the operation of the immigration laws. And I wrote that the USCIS, in requiring the application for a work permit, was misinterpreting the law, that the law gave the right to work, not that an agency had to issue a plastic ID card. And I'm pleasantly surprised that some months later, they in fact reversed their position and said, yes, you can still apply for a plastic card if you want it to put it in your wallet, but you can work as soon as you enter and are admitted as the spouse of a principal worker in those three categories. And so, but that's not the end of the story, though. Some spouses have pre-existing employment arrangements in their home country, and those employers don't want to lose the value of that talent. And so a contract already in existence to provide services to a foreign company and pay in a foreign currency is treated by some interpretations of the immigration law as work in the United States if it's performed in the United States. I don't think it is work. And I say that because we have a purpose behind our immigration law, which is to protect. Part of the purpose is to promote business, but another part is to protect domestic labor. And that kind of a contract doesn't impact domestic labor at all, because that foreign country was never going to recruit someone in the US to do the work. that they needed done. And so the Supreme Court has sort of supported what I've said indirectly. They've never definitively answered this question, but they basically say that we do not interpret our laws to apply outside of our borders. If we were to do that, then every other country in the world would do the same, and it would be intergovernmental chaos. So unless a law says specifically this law shall apply outside of our borders, it will only apply domestically. And that's the immigration law. It does not say it will apply outside the borders. So I think there's a basis with counsel carefully structuring the arrangement for a spouse to work in the US, even though if you were to talk to a number of immigration lawyers, I did a blog post, immigration lawyers arguing, which is posted on my blog, where another respected colleague offered an opposite interpretation. But I think it can be done, and it has to be done carefully under guidance of counsel.
I need to ask you now about the EB-5. That's an investment vehicle, isn't it?
Yes, yes. EB-5, it's not one of my favorites, but it is very popular and it fits certain circumstances. The reason it's not one of my favorite, I have multiple reasons, but some of them have been addressed in a congressional enactment last year called the EB-5 Reform and Integrity Act. But historically, the EB-5 has required a two-step green card process, so that it says initially the amounts were 500,000 as a minimum in what is called an agricultural area or a rural area or a targeted employment area which has exceptionally high unemployment, or $1 million. So that's what it started out. It's been increased since then with the passage of this new act, but it only gave you a two-stage green card so that you had to commit the investment. The investment had to produce a minimum of 10 jobs per investor. And what we found out was that individuals who are entrepreneurs oftentimes could not create 10 jobs during the conditional residency period of 10 years. And so Congress changed the law to create something called a regional center that said, okay, if 10 jobs can be directly or indirectly created by the economic activity associated with the investment, we'll say that works. And so a number of organizations sprouted up, and they're called regional centers. And all they do is allow the indirect job creation calculation to be applied. The problem is that it wasn't enforced and regulated, and a lot of fraudsters entered into the market. That's been cleaning out, but it takes time. And still, an investor is somewhat naive to U.S. business investment opportunities, so they need professional counsel. You do get a green card at the end of the stage, but it could take years, whereas there are other avenues that are faster that lead to an unconditional green card right from the start. And so I would say that it should be one arrow in the quiver in terms of immigration options, but it shouldn't be the only one. You can run an EB-5 parallel with an employment-sponsored or self-sponsored green card strategy as well, and some people do that.
Thank you so much for that in-depth review of the whole, that sector of services. I have another question about what should high volume buyers of immigration legal services, which I guess is a big corporation, what should they expect from the provider?
Well, we've seen with labor shortages around the globe, demographic changes where populations such as in the United States, Europe, and Japan are aging. Pension programs and Social Security programs are predicted to run out of cash, that there has to be a replenishment of talented, high-skilled, and low-skilled workers to keep these economies running. And therefore, what employers are finding is that, notwithstanding that their business is business and they need to make a profit, they also need to attract and retain top talent. And that is ever more challenging when you come into the buzzsaw of very old immigration laws that are not attuned to the modern economy, the modern technological world. So what they should be asking is, what will our employees experience if you are our immigration lawyers? Will it be a remote kind of scripted statement? Well, this is what the law provides. Or will it be a journey that you walk them through that says, these are the various options. We could consider A, B, or C. Here's how they apply to you. And modern workers today are very tech savvy already, and so they want a suite of integrated tech tools. Similarly, the companies themselves want integrated technology. And in the RELO, global mobility, tax, and immigration space, we learned when President Trump announced the initial travel bans that many companies didn't know where their people were. They didn't know what their nationality or residency status was. And so I would call it the Holy Grail, which is the successful champions in this space. And I think Vialto is definitely one, pardon the promo, but the successful champions in this space will integrate it so that there can be instantaneous reporting on the whereabouts, the status, expiration dates of the workforce. They don't want to ask for what is your passport number each time a provider is requested to provide a service in this ecosystem. They want it all in one place. They want it to be simple, clean, functional. But they also want immigration with a heart, with empathy toward the employee. Because if the employee experience is sour, the whole system falls apart.
Let's turn to another topic on merger and acquisitions or spin-offs or whatever. The role of immigration, of course, in a cross-border company is very important.
Well, surprisingly, and this is not my experience alone, but many immigration lawyers have bemoaned the fact that immigration is often an afterthought. And it is forward-thinking clients led by forward-thinking corporate counsel will consider immigration before the ink is signed on the deal. Certainly after the transaction has been formalized, there should have been due diligence conducted to determine who are the key personnel that need to transfer from the target company to the surviving entity in a corporate restructuring. And are those non-citizens going to be able to work without interruption after the deal closes? Are they going to have to go back to the end of the line and wait for decades on a new visa quota system because they're now employed by a new employer? And will there be any smoking bombs or guns if it turns out that the seller had engaged in misbehavior under the immigration law? So there has to be a compliance review process. And what I have found is that there are ways to deal with this. It's a principle known as immigration successorship in interest, where the surviving company gets to accede to the rights of the predecessor, the target company, and all of these concerns are addressed. So there's no interruption in employment. There's no having to restart the residency process. And there's no worry that the immigration enforcement people are going to be knocking on your door.
So with the labor stoppages going on. There's such tumult going on. It's just unbelievable, really. But it's going on. Strikes, not just in Hollywood, but the auto industry now,
Right.
and other labor unrest for sure is probably coming. Um, what happens to immigrants or the people who've come over? And I mean, it sounds like it's a nightmare.
Well, bear in mind that we have an administration that is very supportive of organized labor. Historically, one at the ultra edge of protection of labor, and so they are going to, within the Biden administration, do whatever they can to support worker rights. Now, the way that the immigration regulations in the U.S. are written, you basically have to look at certain points in time. Is the non-citizen outside of the U.S. or in the U.S.? Has the non-citizen received a visa and is working at the job site where the strike is occurring, or are they waiting to get the visa? And basically, the law says this: if the Secretary of Labor declares that there is a strike, a work stoppage, a lockout by the employer in a particular job at a particular location, then they should inform USCIS within the Department of Homeland Security, and that agency should suspend or cease approving any petitions or applications for persons outside the U.S. who have not come here, or if they have come here, they have not shown up for the first day of work. Those persons are not going to gain any benefit because the government is fearful that they could become scab workers and try to break the strike. On the other hand, if a worker is already in place, non-citizen, has the work visa, is working on the job, and a strike is declared, then what the government says is that worker can participate in that organized labor union activity without being treated as violating status. Now, normally, if you stop working in a job for which you were sponsored, you can go out of status. That means you can be subject to deportation. Your family could be forcibly removed from the country. It doesn't happen quickly, but it does happen. But in this instance, they say it will not be treated as a violation of status if the employee participates in the strike. So it basically depends on at what point in the process does the employee sit. If it's before the visa approval, entry, and start date of employment, they're out of luck. If it's after, they're protected. There's one other thing you might want to understand, and that is that the Biden administration has created a whistleblower program for non-citizens who are completely out of status. They may have crossed the border illegally, but they may be working. And if they are a witness to worksite exploitation, violation of labor and employment laws at the state, city, federal level, they can report what they know to the Department of Homeland Security. And if it's seen to be credible, those individuals will get a freestanding open market work permit, and they won't be deported, at least for a prolonged period. And so there's an incentive that employers should be aware of, that some workers who feel exploited are going to become witnesses for the prosecution.
Well, that's a wake-up call.
I didn't mean to kick you in the stomach here.
Well, okay, let's talk about an unjust work visa refusal. That's a mouthful. And so I'm not an attorney, of course, but
Well,
I'm just reading words here and I can't
yeah.
even understand what I'm saying.
Well, basically, our system operates on the idea that an employer, in most instances, will sponsor a worker for a particular category of visa and demonstrate that the individual and the employer both qualify for that visa. But there are adjudicators that are housed at the USCIS. And I should tell you that many of those adjudicators are former police or military personnel who might not take warmly to immigration generally. And so they may look very skeptically at a case that a good faith submission and the lawyer and company behind it believe is deserving of approval. They may ask for more evidence. That additional evidence is submitted, and there may still be a refusal. So what do you do at that point? Well, at that point, the person has no right to work, and the company has no right to employ that individual. So both parties have a big problem. Now, there is, in theory, an appeal procedure, an administrative procedure, but it is not very functional because it doesn't allow the status quo of being employed to be maintained. So persons have to go off the payroll, and then it takes maybe 6 months to a year or longer to get a decision. And what do you do in the meantime? Because you've been waiting, violating the law, accruing what is called unlawful presence. So increasingly, there is litigation against the government for unjust denials. And the litigation can be on an individual basis. It can be on a class action basis. And many employers are very skittish. They may be willing to fight the government in public around other business important issues, business significant issues, but they don't want to be seen as violating the immigration law. Beyond the fines, it's the brand damage. And so many are reluctant to litigate. But perhaps the employee who is on, the firing, facing the firing squad, may have less compunction against litigation. And so sometimes an employer might provide the financial resources for the employee to sue, and the employee would have standing to sue. Other times, there is a major issue of legal interpretation, and agencies are sued on that basis, sometimes as a class action, sometimes with associations such as the U.S. Chamber of Commerce being the primary plaintiff, with a declaration from at least one company saying this is unjust and explaining why. And we have something called the Administrative Procedure Act that allows a federal court to order an agency to change their position. And so, and other times, an unjust refusal just begs for media attention. The government immigration authorities are very skittish about unfavorable publicity. And if they are caught doing something flatly wrong, it embarrasses them. And so, a friendly reporter may be the solution you need. And sometimes a blog post might do it. But you have to understand that there are different ways to approach persuading the agency to change their mind. Also, bear in mind, there are many different points of leverage within the system, because there's the Department of Labor, Department of State, Department of Homeland Security has 3 components, plus they have an ombudsman. And so, and you can always reach out to your member of Congress. So there are ways for the government to be pressured to change their position. Sometimes they do, sometimes they dig in their heels. But if you give up, you certainly have lost.
Talking with Angelo Paparelli, as you could see his name here under him. It's angelo.paparelli@vialto, vialto.com. Angelo, thank you for this lesson. I've been to school here, and I welcome the education. And
I hope it was accessible, though, because I try to keep it simple.
Well, you are a wealth of experience and deep knowledge, and I'm really honored that you came on Global TV Talk Show. So thank you.
Thank you very much. I enjoyed it.
And I welcome you to come back at another time, and we'll have a follow-up conversation, I'm sure. In a couple of hours, I'll be able to send this program to you.
Thank you so much.
Okay, thank you. Bye-bye.
Bye.
Peace. Thank you.